several times over the past 6 months with no response. I cannot get an answer.
I'd like to.
The dramatic opener. Hook, whoa. Right out of the gate, we're in the middle of an argument. The defendant is accusing his lawyer of dropping the ball, but the lawyer is hitting back hard, calling it complete nonsense. This immediate tension sets the stage for a messy, emotional hearing. This is why you always need solid communication with your public defender. It can make or break your case.
Responded. That is complete nonsense. He has been in my office. He has met with me. He has reviewed the evidence. I've discussed the case. It got to the point where he offered me extra money, somehow thinking that was going to change how I represented people. And I said, I've acquitted people on murder charges on appointed cases.
No, this is your attorney.
Worked with him the first time. I told him I didn't want him to be my attorney. But you won't give me a chance at probation, but you give everybody else that has a long record a chance at probation. And they have the same cases as mine.
All right, so I'll tell you.
Yes, ma'am.
I don't think you're appropriate for probation.
Yes, ma'am. I don't want to say that you're moving too fast, Miss Boyd.
No.
Miss,
That's fine.
It's the people that was around me, ma'am. My family did not want to see me make it. To do 6 years, Miss Boyd.
You'll get credit for any time that has been served.
Tell me
I understand nobody wants to go to prison, right? But you're going to have to start doing the right thing. The court will find you guilty. The court will sentence you to 10 years.
Legal clarity in stakes. The reveal, wait, hold on. The judge just sentenced him to 10 years. But if you rewind a second, he was charged with aggravated robbery, a first-degree felony with a range of 5 to 99 years or life. 10 years is technically on the lower end, but this segment is actually from a prior hearing where he accepted deferred adjudication. This is a massive legal lifeline. It means if he successfully completes probation, the conviction is wiped from his record. What do you think? Is deferred adjudication the perfect second chance, or a ticking time bomb for someone struggling?
Yes, ma'am.
Did you understand? In count one, you're charged with aggravated robbery. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. We'll schedule this for a PSI and TAP evaluation. Is there a need for mental health evaluation or no?
No, Your Honor.
All right. Then we'll come back on February 8th. On February 8th, I'll make a decision on your application.
Thank you, Judge.
All right. Thank you.
There's a mental health factor in this case, and you can see that in the PSI. Draw your attention to page 9. I think he would profit, and so would society, if you would give him supervision. He's motivated because now he has a child to change his life. He's also pushing 40. That's another motivation. The victim in this case was not injured, was threatened, but not injured. And his property was returned to him. I asked the court to consider deferred adjudication with mixed supervision. In the alternative, I asked for 180 days in jail before the imposition of deferred adjudication. I think he would like to say a few words to the court himself.
All right. Would you like to speak? Can you raise your right hand for me?
Emotional turning point. Engage. This is the moment of truth. The defendant, now Mr. Boyd, is about to speak directly to the judge. His lawyers just laid out a heartfelt case, citing a new child, his age, and a mental health factor, schizoaffective/bipolar. When a defendant speaks, it's a huge gamble. It can show remorse and humanity, or it can backfire spectacularly by sounding like excuses. What would you say right now if you were fighting for your freedom? Drop your best defense line in the comments.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Name is Claudel Dwayne Kearney.
All right. Defense?
May he narrate, Your Honor?
Yes, if there's no objection from the state.
Okay.
You may.
Your Honor, I know what I did wrong, and I'm terribly sorry for disrespecting the court by coming up in this place. And I recently lost 2 jobs, and I was hit by an 18-wheeler inside of an Uber, and that's how I lost both of my jobs. And I ventured off to go into the streets And that was my intention was not to. This guy was my friend at first, and it wasn't my fault that I got hit by this 18 wheel and lost both of my jobs. But I just want to say that if I could right my wrongs and to try to pay restitutions and furthermost, I just recently found out I have a child, man, and I came all the way from New Orleans just to try to find her, and I found her, and I deeply apologize, Ms. Boyd, if I know my record is bad, and I'm a good person. I come from a military family, and it's about accountability and holding myself accountable. If I'm wrong, I know what I did, but if I can fix it, man, can I have one chance just to fix it? That's all I'm asking.
Anything further?
And recently my brother just passed away, who I stay with. He went to sleep and never woke back up. He had a heart attack. And my little cousin, I just missed both of their funerals, man. I'm sitting in this jailhouse and I'm realizing how many people is passing away, and time does not stop when you come to a place like this. And I'm tired of my conscience is eating up at me for what I did wrong. But this the hand that I had chose, this the bed that I chose to lay in. And if I can fix it with the victim and help him out as well to try to pay it forward, man, I will. And I will be sure to do that and try to. And also, I don't have the one to look after my child no more, man. My brother was there for her. He was a school teacher. And I come from a nice, beautiful family, man.
So because you come from a nice, beautiful family, why are you here?
I'm here.
No, I mean, why are you? Because I've looked at your criminal history. Why are you say you have a military family. You say you come from a good family. So I don't understand why you're making the choices that you're making in your life. Why are you making these choices?
Judge's brutal question, witty observation. Ouch. The judge isn't buying the good family defense. She's cutting right to the heart of accountability. She's not questioning his background. She's questioning his choices. In court, you have to separate a mistake from a choice. When the judge says, you chose to take somebody else's phone, she's drawing a line in the sand. It's a reality check that is both tough and legally fair. Personal responsibility is the final verdict.
Because you had a choice.
Yes, ma'am.
Buy your phone or take somebody else's phone. You chose to take somebody else's phone.
You know, the crazy part is I had a phone on me that day, ma'am. I had my own phone.
Yeah, so that's why I'm trying to figure out why you're making these choices.
It was a foolish mistake.
And how old are you?
I just turned 38, ma'am, November 15th.
All right, so there are no excuses. Like, what's the excuse for taking a phone and you say you already had a phone?
We had, me and Mr. Ted, we had got into it, and it was a foolish mistake. I should never did it.
No, it was a choice, not a mistake.
Yes, ma'am.
So I'm trying to figure out, why are you making these choices? You tell me you come from a good family. You have a military family. You now have a daughter in your life, and you came all the way here to find your daughter. You find your daughter, and then you're making these choices. Yes. So I'm trying to figure out why.
Okay. I had lost my job, both of them. I was working at Taco Bell in a Ford warehouse, ma'am. And me and my little brother, the one that recently passed away, got into it, and he put me out, and I really didn't have nowhere to go. I was on the streets, man.
What about your sisters?
My sisters, I have 9 brothers and sisters. Once you do one person something wrong in my family, the entire family mad at me, and I didn't have nowhere to go, man. And I went back to the streets, and that was the worst thing I should have never did in my life, man.
All right. Is there anything else?
Nothing further, Your Honor.
Nothing I can say, Judge.
All right. What are you requesting?
Nick Miles supervision, Your Honor, and deferred adjudication, hence, but in the alternative, 180 days in jail as a condition of deferred adjudication.
And state, what are you requesting?
We are opposed to the application for deferred adjudication we're asking that it was a 10 opposed that you oppose that.
All right, probation. And this is just because I love to have more information than not information. This is not saying I'm going to rule one way or the other. Can you explain why DDRF is saying that he does not meet their targeted population, but according to the report I'm reading, it says in 2003, he was in DDRF. It's Claudel Carney. All right, everyone have a seat. I'm gonna think about this.
May I address the court vote?
Yes,
It's 2022, 23, not
2003. All right. Thank you. And are you Claudel Carney?
Yes, ma'am. Good morning, Judge.
Good morning. All right, so this is a case that I needed time to think over. And this is the case probation. Is this the case where there is potential DDRF?
Yes, Judge.
All right. So this is what the court is going to do unless there's more argument by either side?
No, Your Honor.
No, Judge, it's a two-man argument, but we're not hearing.
All right. Court is going to sentence you to 10 years deferred adjudication. There's an affirmative finding of deadly weapon. I'm going to order DDRF. So you're going to remain in custody until you transfer to their inpatient facility, and that's for mental health. You understand? If you would like, I can either sentence you to 5 years prison or either you can do this probation. Which would you prefer?
I'll do probation, ma'am.
All right, so the 10 years deferred, affirmative finding of deadly weapon, DDRF. There is going to be regular reporting. And do you have any family here?
Yes, ma'am.
Do you have anybody who would let you live within here or they're not?
I was currently staying with my brother, and he passed away. So, but I'm still reside at the address 6555.
Oh, no, you don't have to give us the address, but let probation know, okay?
Yes, ma'am.
All right, and there's to be no unsupervised contact with minors. Other than that, no unsupervised contact with minors, because until you have your mental health issues under control, you really shouldn't probably be around minors, you understand?
Understood. Yes, ma'am.
Probation, is there anything else he needs?
No, Judge.
Is there anything else you need from the court to be successful?
Oh, ma'am. I appreciate you helping me also for Your Honor.
Here's the thing. You're on probation, so you need to stay in contact with your probation officer. You have mental health issues, so you need to stay in contact with your case manager. They'll probably give you one. You need to make sure you do all of those things. Do you understand?
Yes, ma'am.
If there's a problem with the medication they give you, you got to let them know what the side effects are. You understand?
Yes, ma'am.
Because if you don't talk to them, they don't know. In this court, to be successful on probation, communication is key.
Yes,
If there is an issue and you feel like probation is not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am, I do.
Yeah. So from here on out, everything that you do, your range of punishment on this case, if you were to mess up, is up to life in prison. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
And counsel, are there any health issues with him? I see issues with his arm.
Not that I'm aware of, Your Honor.
All right,
Mental is the issue.
all right, thank you. For the record, for the state,
Opinion for the state of Texas,
good morning, for the defense.
Christopher Ramos for the defense.
And are you Mr. Carney?
Yes, ma'am. This is me.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Ms. Boyd.
Are you the same Claudel Dwayne?
Yes, ma'am.
All right, are you the same Claudel Dwayne Carney who was placed on deferred adjudication in 2023 CR 10366 for the offense of aggravated robbery on February 13, 2024 for a period of 10 years? Is that you?
Yes, ma'am. That's correct.
All right, state.
Yes, Your Honor, violation of condition number 41. On or about the 8th day of September 2025 in Bexar County, Texas, the defendant, Claudel Dwayne Carney, did then and there fail to register for, attend a moral recognition therapy program with an approved agency in violation of condition number 41.
All right, if we could go off the record for a moment, I don't have a violation of condition number 41. Is that in a supplemental? Did you understand by pleading true to violation of condition number 41, court could find it true, grant the motion, find you guilty, and sentence you up to life in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, Your Honor.
Court will find violation of condition number 41 true. Is there a proposed agreement?
There's not, Your Honor. Both state and defense are going to make the recommendations to Your Honor.
All right, state, what are you requesting?
Before I make my argument, Your Honor, I ask the court to take judicial notice of the court's file.
What specifically do you want the court? I know you say the court's file, but is there something specifically?
The facts of the underlying offense and his history on probation.
All right. You may proceed.
Thank you, Your Honor. We're here for the defendant's motion on this aggravated robbery charge that he is on probation for, and Your Honor is aware of the facts of this case, being that he initially stole that victim's phone, ran away with it. The victim was lucky enough to later find him at a gas station close by, and when the victim asked for his phone back, the defendant pulls a knife on him and says, "Come and take it. Come and get it." With a deadly weapon, he threatened someone's life, therefore being placed on probation, for 10 years. We're here on the second MTR this defendant has had within the last 4 months for same violations as it was just 4 months ago in June, Your Honor, where the defendant had a new number one that we unfortunately had to waive. That victim was his sister. He assaulted her. She did not want to come in to support that day.
Well, you
I
have,
would strongly
object.
all right, that objection will be sustained. If it was waived,
Okay.
then it will be sustained.
We reluctantly had to waive number one today. We were ready to proceed on the contested MTR yesterday. Victim here, sister here, to testify about what he did to her. They decided not to show up today. Therefore, we had to proceed on the technical violation of condition number 41.
Well, I
David?
mean, if you would like, my understanding that there would be no objections. If they would like to zoom in, I was going to say it was working.
Normally, Judge, I don't remember. For the benefit of the record and on behalf of my client, I would have to object on their appearance on Zoom. I would ask them to appear in person.
Okay. All right, you may continue.
Only because of the defendant not coming yesterday, we were unable to proceed with trying to prove the assault that he committed against his sister on September the 4th, 2025.
Okay.
As such, because of the underlying offense, because of his history, because he had the opportunity that Your Honor gave him back in June to go to Louisiana like he requested, but instead chooses to commit new crimes, they feel that he is not an appropriate candidate for probation. He should be revoked. He should be adjudicated guilty. There should be an affirmative finding of deadly weapon. State is seeking that Your Honor sentence him to 10 years TDC.
All right, defense, you may proceed.
Specifically to speak to him not registering or attending the moral recognition treatment course. My understanding is that he failed to, at least the date alleged, is a date in September of 2025. As he describes to me, he was released from jail in July of 2025. And he does admit to me that he did not register for the class. And part of that where he was struggling was a combination of him dealing with, as the court may be aware of, some of his mental health struggles that he's dealing with. He reports to me that he is schizoaffective, dealing with bipolar. I believe probation has some information about that. And he was also struggling with transportation. At this moment in time, in September, I think he was just struggling to function as an individual. He's just struggling to function. But I would ask the court to be mindful that while on probation, as far as I can tell, he's completed some of the outpatient requirements. He's completed anger management. There were a series of events where he tested for substances and he came back a series of times negative. He's been to DDRF, and when I ask him about his experiences there, he's able to recite their philosophy, the things that he learned. He's describing that he learned strategies on avoiding conflict, on what his triggers are. And other than this allegation of assault and a minor relapse with the substance, I think he's doing the best that he can. I think he was living in a household that was pretty volatile. And I think he's living with other individuals that struggle with them. They struggle in terms of how to deal with his mental health issues, and it's a bad recipe.
Mm-hmm.
I have a sense that he's doing his best. He describes to me he wants to fight the new number one as it exists on its own because it's a new case. So we are respectfully asking the court to continue him on probation with some sort of jail sanction, and to be mindful that he has given his mental health. He's doing his best to accommodate. That's the wrong word. To fulfill the agreement he's made for probation. So for that, Judge, we're asking for you to continue him.
So here's the thing, Mr. Carney.
Yes, ma'am.
I don't think you're appropriate for probation.
Legal hammer drops the revocation, and there it is. The ticking time bomb has exploded. The judge revokes his probation and imposes a 6-year prison sentence. Remember that 10-year deferred sentence from earlier? She just pulled the trigger on a portion of it. The finding of violation of condition number 41, failing to register for a therapy program, proved he couldn't meet the terms of his freedom. This is a devastating example of how a technical violation can cost you years of your life.
I granted your application over the objection of the state.
Yes, ma'am.
And I can only do so much. What the court is going to do is the court is going to find violation of condition number 41 as previously stated. The court is going to sentence you to 6 years in the prison, give you credit for any time served. The court will recommend the therapeutic community. There's an affirmative finding of deadly weapon. The court will give you credit for any time served for successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am. I don't want to say that you're moving too fast, Miss Boyd. Judge.
No.
Miss.
That's fine. You can call me Miss Boyd.
My principal in Shelman Middle name was Mr. Boyd.
Okay.
Ma'am, I get it. I just came home November 1st and consistently back in your courtroom, and I am ashamed. Also, ma'am, the new class that you signed me up for, told me to go to, I didn't have no transportation. I didn't have no kind of ride. I'm getting kicked out of this house that my brother had owned, caught a heart attack in, and they had multiple individuals in there. I haven't even spoke my mind about what's going on in this house, from guns, drugs activity, and Center for Healthcare helped me, got my food stamps. Just one of the two same sisters are stealing my food stamps. Those are triggers that I learned. So I removed myself from that household consistently. But I always went back because you know why? That's where I probate to. That was my original.
No, so here's the thing. I tell everyone who's on probation in this court, if there's an issue, all you have to do is let probation know about it.
I did, Miss Boyd. And also, I was trying to tell you, like, recently, I just cleared a $25,000 lawsuit. Only thing I did for myself, ma'am, was buy a brand new car. It was $12,000. It's in New Orleans. My niece was driving it to me the day that I got locked up, ma'am. Consistently, if the system, I'm not going to say the system failed. I love Mr. Alcatar, my probation officer. I wish he could speak up on my behalf. Ma'am, no. And I just moved back to San Antonio because I just recently found out in 2023, I have a 12-year-old baby that I did not know I was able.
So here's my question. Why didn't you contact probation and say all of this was going on in your life?
I tried, Miss Boyd. I really did. Because I was in jail. I didn't know not one, but two of my siblings passed away. One of them overdosed from drugs. And
so here's the thing, what I want you to internalize.
Yes, ma'am.
This is what I want you to internalize. I took into consideration your mental health issues when I granted your application for deferred. And I granted that application for deferred over the objections of the state. So what that means is you need to be on what's called your P's and Q's and make sure that you're doing everything that you're supposed to be doing. And you're not. So I just don't think you're appropriate for probation. So I'm not going to continue you.
Yes, ma'am. Mr. Alcatar, I can have a peaceful word with Mr. Alcatar before I leave.
For what purpose?
because he could tell you some of the things that I was going through before I got locked up, ma'am. I was explaining the stuff that you said that I wasn't explaining to probation.
Mhm.
I was explaining to Mr. Eckletar. I knew it was going to be. I didn't know how it was going to happen, but I knew it was going to happen. I was going to fall off, ma'am. I just bought this car. I didn't have no transportation to make the last class, and I was going to complete the last class. I even much have the money right now to pay off my whole probation. I just didn't. It's the people that was around me, man. My family did not want to see me make it. I have all my probation fines and fees, the whole 7,000.
Oh, here's the thing. Your attorney can address with you whether or not you should be spending money to pay that because you're no longer on probation. That would be money that
So I to do 6 years, Ms. Boyd.
you'll get credit for any time that has
You
been
could tell
served.
me how much time served that do I have?
To the clerk, can you look up how much time?
And what about the credit for time served the last time when I was?
You'll get credit for any time that you've been in custody on this case, even prior to being placed on probation. Did you review the trial court certification of defendant's rights to appeal? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion.
Yeah.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, Ms. Boyd.
All right, thank you. You're welcome. In each cause number, the court will find that the state is in compliance with discovery. Mr. Garcia, in each of the cause numbers, did you have a chance to review the true bill of indictments with your attorney?
I looked at them, yes.
All right.
But
So-
Your Honor, I was under the impression I had a different attorney. When I went to the PR jet, they told me Michael De Leon.
No,
Because
this
when
is your
they came to
attorney.
work with him the first time, I told him I didn't want him to be my attorney.
Well, this is your attorney,
I was
counsel.
satisfied with his service.
Well, he's your attorney. Do you understand?
Satisfied with I want to withdraw my plea. Because the indictments aren't correct anyways. I've never been convicted of a manslaughter.
Mhm.
And it says I've been convicted of a manslaughter on there. I wasn't in possession of a gun. It was in the glove box of a car that's not even in my name. That I told him I would sign a statement saying that the gun belonged to the owner of the car.
No, so here's the thing, and I'm going to explain some things to you. Owning a weapon, if you have a prior felony, it's not so much whether you own a weapon, it's whether you're in possession of it. And it doesn't matter when you went to prison. If you went to prison, you're not allowed during specific time frames, during anniversary dates, you're not allowed to possess a weapon.
Your Honor. I was a minor, 1989.
All righty. Well, I mean, what are you talking about? What was from 1989?
The gun and the manslaughter that they're talking about. I was a minor. I was a juvenile.
So you are the person with the voluntary manslaughter. It was just when you were 15.
No, I never had one.
You just told me you did.
Correct. That's what I said. What they're saying I had. That's wrong. I've never been convicted. So that indictment's not even correct.
You just told me that's who you were.
No,
You said when you were 15.
I said when they said I was 15. I was 15 years old, but they're accusing me of that.
Mm-hmm.
But I never went to court for that. I've never been convicted of that.
And
Well-
the state's waiving that paragraph.
I did waive that, Your Honor. So
That's
I'm
from
not
Cleveland,
sure.
Ohio. That's not even from here. That's
So
from over 20 years ago, man.
I understand that. I waived it. So we're not accusing him of having been convicted of a voluntary manslaughter. We
Well, they didn't
did.
give me a chance for probation, but everybody else had the same cases. I'm listening to them today, the 2nd-degree felony, and you're giving them probation and deferred adjudication. I haven't been in trouble in 20 years. I'm 52 years old. I go do 10 years. I'm probably won't even make it out alive because of all the gang in the prison. I've never been in trouble in Texas. Never, man. But you won't give me a chance at probation, but you give everybody else that has a long record a chance at probation. And they have the same cases as mine.
All right. So I'll tell you this, Mr. Garcia. What I do know is you can't compare your case to somebody else's case because you don't. But here's the thing. You don't know what evidence they may or may not have had with that person because every case is different. Sometimes people will say, I can't believe this person who is charged with a murder got 5 years and here you are offering me 40 years. It's because every case is different. And I understand that sometimes people have
The takeaway message, summary, and transition. We shift gears to the next defendant, Mr. Garcia, who is also desperately pleading for probation, comparing his case to others. But the judge's response here is the ultimate legal insight for any criminal case. No two cases are the same. The evidence, the victim, the judge's mood, it all matters. What a powerful, emotionally charged day in court. If you want to see if Mr. Garcia fares any better than Mr. Boyd, stick around for the next video.
changed their lives, right? And they want people to recognize that they've changed their lives. But I'm just dealing with cases before me. Either I'm going to follow a plea agreement that you all have reached, or either I'm not going to follow the agreement. That's where we are. So, Mr. Garcia, the indictments are to tell you what you're being charged with. So in 2024 CR 0090-02, you're being in charge with unlawful possession of a firearm by a felon. And in 2025 CR 012431, there are two counts. The first count, you're being charged with manufacturing, delivery, a controlled substance, penalty group 1, 4 to 200 grams. Count 2 is possession of a controlled substance, penalty group 1, 4 to 200 grams. What I can tell you is, when you have just, this is what I want you to do. This is what I want you to do. I want you to listen, okay?
Okay.
This is just what you're charged with. Now, the state and the defense may come to an agreement to say, this is what you're charged with, but we're going to go on a lesser included offense. Or they may say, this is what you're charged with in counts 1 or count 2, but we're only going to proceed on count 2. What I'm telling you is, I haven't even got to the point of what your plea bargain agreement is. I'm just showing you the indictments. This is what you're being charged with. Do you understand?
Yes.
And counsel, did you go over the indictments with Mr. Garcia and explain it to him? Do you waive the reading of the indictment? State, in the cause number 2025 CR 012431, which is the drug case, are you proceeding on the indictment as presented?
We are not, Your Honor. We are waiving count 1, which is the Mandel count, and we are only proceeding on the possession count.
All right. Any objections to the waiver?
No.
And then in the cause number 2024 CR 0090-02, which is the weapons case, are you proceeding on that indictment as presented?
We are not, Your Honor. We are waiving both of the enhancement paragraphs and proceeding only on the allegations contained in the jurisdictional offense, unlawful possession of a firearm by a felon.
Any objections?
No.
Now, Mr. Garcia, I'm going to show you the court admonishments. These documents tell you what your rights are, and it also contains in it what your plea bargain is that you have negotiated with the state. Now, because you've negotiated a plea bargain agreement with the state, that doesn't necessarily mean that I will follow the agreement. I'll have to read the stipulations and everything else. So in 2024 CR 00902, 90-02, you're charged with unlawful possession of a firearm by a felon. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. In 2025 CR 012431, you're charged with possession of a controlled substance, penalty group 1B, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years with a possible fine up to $10,000. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Good.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand? By entering these pleas, you're giving up those rights. And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yeah.
Counsel, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Okay.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
All right. If you're not a U.S. citizen by entering into these pleas, you will be deported, denied naturalization, or re-entry. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
In each cause number, your punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. The cases will run concurrently. The state is taking in consideration 2025 C011469. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraphs with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
None.
And cause number 2024 CR 0090-02. How do you plead? Guilty, not guilty, or no contest?
No.
And cause number 2025 CR 012431. How do you plead? State any evidence?
In both causes, Your Honor, the state offers into evidence states Exhibit 1 and its.
Okay.
Right. In each cause number, did you review the waivers and stipulations?
Yes.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand in entering these pleas, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you waiving PSI?
Yeah.
Anything you wish to say on behalf of your client? Now, Mr. Garcia, on the drug case, I read the police report, and in the police report, you had the drugs in your pocket. Yeah. So, I mean, in the drugs you had in your pocket, the weight of the drugs was 28.564 grams.
Yes, ma'am. No.
So, I mean, here's the thing. I understand nobody wants to go to prison, right? But you're going to have to start doing the right thing. So in cause number 2025 CR 012431, the court will find you guilty. The court will sentence you to 10 years, give you credit for any time served. There's a $1,500 fine, time and money to run concurrently. Taking consideration 2025 CC 011469, and this will run concurrent with 2024 CR 0090-02. And then in the other cause number, you admitted that there was a weapon in the vehicle. Yeah, I mean, you told the police, yes, there's a weapon in the vehicle. So that's care, custody, and control, and you're considered to be in possession. And you're not allowed to do that because of your criminal history. So in cause number 2024 CR 00902, the court is finding you guilty. Court will sentence you to 10 years in the prison, give you credit for any time served. There's a $1,500 fine. This will run concurrent with 2025 CR 012431 and 2025 CC 011469 will be taken in consideration. Is there anything else, counsel, with regards to sentencing?
Further.
And each cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Oh,
That's
The
good.
county court, you'll have to
Oh,
take
okay.
it there. They
All
don't
right.
want to sign it.
Which one? 12? Okay.
Yes. Well, yeah. All right. Did you review? The trial court certification tells you whether or not you have the right to appeal. Now, because I followed your plea bargaining agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand? All right, we can go off the record, Mr. Garcia. If you don't start making better decisions, you're going to find yourself living at the prison. You understand? All right, good luck to you, sir. Thank you, attorney.
Thanks, guys.
All right, thank you, Fernando.
Yes, Judge.
Hi. What did I see where she pled to count 2, but there is no notation of how did she plead to count 2?
I believe there's a no contest plea, Judge.
All right. And are you Adela Rodriguez?
Yes, ma'am.
And did you enter a no contest plea to count 2?
Yes, ma'am.
All right. We're here for sentencing. According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison and the state is silent on your application. They're taking in consideration NIMAG number 693985 and 693984. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Judge.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor, just would like to argue some clarification if we may.
All right, you may proceed.
Thank you, Judge. As the judge has seen in this PSI, Ms. Rodriguez accepts responsibility for this instant offense and has expressed her remorse for being in this situation. As the court can tell, there is a little bit of a checkered past of her, 50 years of being on resident of San Antonio, but the last 10 years or so have been pretty clean. The one thing that I noted on this PSI is that normally there's, especially in the TAP evaluation, there's sometimes language about how an individual is not motivated for bettering themselves or for helping themselves with any difficulties that may be out there. That's not the case with Ms. Rodriguez. She's actively willing to participate in whatever is necessary. The recommendation is for residential treatment at this time, Your Honor, and we would just ask the court to consider, in the interest of justice and the totality of the circumstances, to allow Ms. Rodriguez to begin, if the court is gracious enough in the interest of justice, to grant her community supervision, allowing her to begin such community supervision by permitting her to either sink or swim through outpatient treatment. In the alternative, Judge, if in the court's wisdom, the court believes that the inpatient treatment recommendation is appropriate, we would ask that the court sentence Ms. Rodriguez, but allow her to turn herself in tomorrow, come here to the courtroom, or however the court would like us to do that. There are just a couple of matters that Ms. Rodriguez needs to immediately take care of, but she'd be available to come in first thing in the morning, knowing that by not doing so, it would only make life worse for her. And as the court can see from the pre-sentence investigation and her appearances and behavior before this court, before this day, that is outside of what is in her best interest, and she's aware of that.
All right, anything you wish to say?
No, ma'am.
All right. So I always reread the police report and read the PSI report. And so this is drugs wrapped in plastic baggies.
Okay.
So that doesn't appear to signify personal use. You understand?
Yes, ma'am.
All right. This is what the court is going to do. Court will find you guilty. Court is going to sentence you to 6 years in the prison, give you credit for any time served, take in consideration NICMAT number 693985, 693984. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You need to do better.
Thank
you.
With this contact, there's some offering. You think there was
Who's here on Andrew Hutkins?
Ready, Your Honor. James Seeloff for the defense.
All right, the court is calling 2022 CR 7318, State of Texas versus Andrew Edward Hutkins. Can I have parties approach and announce for the record for the state?
Officers.
Hank Wilkins for the state.
Defense? For the defense?
James Seeloff for the defense.
And are you Andrew Edward Hutkins?
Yes, sir.
Showing you what's in. All right, see y'all back here at 1:15. We're scheduled for jury trial today.
Oh, I understand, Judge. I was going to tell the court that I'm flying out. First, I have a mock trial competition. I've been on a vacation letter. I'm flying out tomorrow, and I will not return until the 17th. Vacation letter's been on file with Bear County.
All right.
It's also my anniversary, and my wife is also flying as an assistant coach with the teams. We are going to be on a plane tomorrow from Houston, flying out at noon. So we'd ask, or I would ask for the court to allow a new trial setting to accommodate.
Did you file a motion for continuance?
I haven't. We are on a vacation letter, but if the court requires me to file a motion.
Okay, this is what everybody needs to understand. A vacation letter is just a vacation letter, but motion for continuance needs to be filed.
I understand.
See y'all back at 1:15. Victor Del Toro.
Yes, Judge.
MCR 5164, State of Texas versus Jonathan Boyd. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jason Goss for Mr. Boyd.
All right, so this is set for jury trial today.
Yes, Your Honor.
Yes.
As the court has, I see the court has read the motion. Our motion is based on an error that's been made by Mr. Boyd's trial counsel, which is me. We have, until yesterday, I have reviewed the labs and reviewed everything else and the other evidence in this case. And I erroneously interpreted the labs as not including any DNA. I'm not excusing it. It was just a mistake on my part. The lab formatting was a little different. There are a lot of different areas where it shows what I thought it did. And then there's a break in the formatting, and I can introduce it to the court to show the court. It is done from an Austin lab. It was not done in the Bear County lab. It was not done in the format that I was familiar with. And I have gone for a long time now under the assumption that there was no DNA in this case. I was informed by Ms. Mitchell yesterday that she said that, and I disagreed with her. I said, this isn't a DNA case. I even sent her the lab and said, I don't know what I'm missing. I've interpreted this as no DNA in this case. It's a mistake on my part. Now, the concern that I have is that based upon that, I haven't been able to advise my client. There was a plea deadline that this court made that, I mean, we've done everything that we've done based on my erroneous understanding of this document. And so I have not prepared to defend against a DNA case. I've also not advised him based on his plea bargain offers that have been made to him. I haven't been able to advise him based upon DNA. I have immediately requested, which I hadn't requested before under 3914. Once I found this out, I immediately requested the lab notes and the bench notes and other things that I would need to be able to meet a DNA, to challenge DNA evidence in court. I've requested those from Ms. Mitchell yesterday. I've also filed that request with the court. So it is my mistake. I'm not trying to excuse it, but I just would like that my client not have to go to trial on a case this serious with an attorney who has, at this point, who is not prepared to meet that evidence. But I can be prepared to meet that relatively soon, as long as I have those documents, which I believe it's relatively easy for them to get in the discovery pack.
So how long have you been on this case?
2 years.
And this is the first time the first time you're discovering that there is DNA and it's alleged to be positive?
Yes, Your Honor. I have read this lab report. It's not that I just missed a report or didn't read the discovery. I read the lab report and erroneously interpreted it. And that's my fault. And, you know, Ms. Mitchell can attest to the fact that she knows that it was erroneous. I'm not trying to waste time. I literally, to her yesterday, said, I still believe that there was not a DNA report or a positive DNA report, and went forward as that. And so that it's a mistake on my part.
So you're asking for a continuance?
Based upon that, because I am not ready for that. And I guess I would also ask, I know the court has had a plea deadline, but I would also ask for, once I'm able to get that, to be able to renegotiate with counsel, because I've been advising him not based on the fact that there's a DNA positive result, which if that holds up after our investigation, I'd like to be able to an opportunity to renegotiate or to talk about a plea past the deadline, because I just didn't know. And as the court knows, that makes a big difference as far as whether the client is going to accept a plea or not to accept a plea.
State.
Your Honor, it is a test result from DPS, and it is not in the normal format. It is buried, so I can attest that it was a surprise to him yesterday. What he said is accurate. Given the fact that there is not a discovery packet that has been requested, and there may be things in there. I feel like I need to agree for this continuation.
And where is this other information that he now wants, now that he has read that there is alleged to be a positive DNA test?
There is a discovery packet that the labs put together that will have all of the chain of custody and the notes.
And where is that?
We don't have that, Your Honor.
So does somebody want to call on the phone and find out where that is?
Yes, Your Honor. I believe that I will tell you that in ordinary courses, the lab will have that ready, and they just need a request from the prosecutor, and then they'll email that or put it on a disk.
Okay.
All right. Come back after you call.
Thank you, Your Honor.
Mm-hmm.
As a prosecutor,
Yeah. All right. We're going to go on the record in 2021 CR 5164, State of Texas versus Jonathan Boyd. Can I have parties announced for the record for the state? Depends. And are you Jonathan Boyd? All right. So we were here because the defense, you were asking for a continuance, and the state had no objection to your continuance. Is that correct? All right. The court will grant the continuance, Mr. Boyd. I think that everyone should have everything and see everything as it exists in reality, for want of a better term. So I am going to extend your plea deadline date. We're going to come back on Thursday. Are you employed?
Tomorrow?
Yes.
Yes, I am.
All right. So we can do it. Well, we can do it by Zoom. Are you able to do it by Zoom? All right. What is your break at work?
Well, I'm self-employed, but I just have.
All right. What time?
9. Anyone?
All right. So we'll put you at 10 a.m. So your attorney will get the Zoom link. So you Zoom in at 10 a.m. So what we're going to do tomorrow is, with regards to the DNA information, without objection from either party, you all were in agreement with me calling the DNA person to get the packet together. Is that correct, State Defense? All right. So they were giving you all a month's date, but when I talked to them, they said they think they'll be able to have that packet prepared by next week. So I've given them come on in. I've given them my cell number without objection from either party, and my email address without objection from either party. So what will happen is, if they send me anything, that will be forwarded to both your counsel and to the state. If for some reason they email me the packet, which I don't see them doing, but if they do, I don't read any evidence or proposed evidence that's sent to me. I will send it out to your attorney and the state. And then of course, afterwards, if somebody wants me to read something, then I will do it at that time. Is there any objections to that process, state? Defense? All right, so we're going to be back tomorrow at Thursday. I've granted your motion for continuance. I'm going to extend the plea deadline date, but when we come in on Thursday, hopefully I will have the exact date next week when they will have that packet. And then on Thursday, you'll be able to get your new jury trial date and plea deadline date. All right, is there anything else? All right, so I'm going to see you tomorrow on Thursday. Your attorney is going to inform you, and I will inform you when you're on Zoom tomorrow because you have to work and I want you to miss work. I will inform you on Zoom tomorrow when your next jury trial date is and your next plea deadline date is, okay? And the plea deadline date and jury trial date will be the same. But I'm asking that if there's going to be a plea entered, don't wait to do it on the day of the jury trial because we'll be thinking a trial will be going, state will have their witnesses or not. So everyone make sure that that's done before we get to the jury trial date. All right, is there anything else? All right, we'll see you on Thursday.
Yes, Your Honor, I believe that the lab has delivered the CD. I haven't been able to see the CD yet, but I believe it has what
it is in transit down.
Right. I guess just with the caveat, once I open it up, if some of the things aren't there that I would expect them to have, I might have to add those things too. But
all right, you all are getting a jury trial date. Miss Ferguson, I want this either the second week or the first week in August, whichever day is family violence.
Your Honor, if I could, so I have spoken to our expert. I reminded the court of that last time I was here.
Mm-hmm.
He's going to need 4 weeks or so to get the report.
He's going to have to do a brush.
He's in Italy at the moment. He was the one that went to testify.
And when is he back from Italy?
Well, I think he's coming back this week, and then we're out all next week.
All right. So, Ms. Ferguson, put this in the beginning of August whenever family violence has their jury trial. This case has been on the docket since 2021. So, counsel, who is the actual person who's going to be trying this case?
Mr. Goss, Judge.
All right. I'm not giving any further this is another case. I'm not giving any further research in this case. Ms. Ferguson, on Jonathan Boyd, give me a jury trial date soon on this case.
I think we've given them.
I'm not talking about it, so.
Yeah. Actually, the court.
Yeah, I know. Yeah, but that is this one, right?
Yes. We're coming back on September 18th, and somebody from your firm needs to be here to try this case.
Got it, Judge. May Mr. Boyd be excused for the day?
After he signs the reset form.
Thank you, Your Honor.
Just 1 second. We're going to go on the record. Court is calling 2021 CR 5164, State of Texas versus Jonathan Boyd. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Gary Hillier for Mr. Boyd.
And are you Mr. Boyd?
Yes, ma'am.
Okay. So are you the attorney of record for this case?
I am not, Judge. I am associate of Mr. Goss. He is the attorney of record. He is currently in jury trial in the 186. So
all right. Do you have any objection to this attorney standing in for Mr. Goss?
Today?
Yes. All right. So they filed a motion for continuance. State, do you have any objection?
Your Honor, the state is ready. However, I mean, Mr. Goss is in trial, so I understand. It's not possible.
And if I may, Your Honor, just for the record, as we're on the record, if you recall last time, Judge, you helped us get the bench notes for the DNA in this case. And my understanding is, although it's Mr. Goss's case, that they are still being looked at by an expert.
Oh, yes, somebody who's in Italy. So he needs to be here on that date. It's going to trial on that date. So I suggest, this is just me saying, maybe somebody wants to subpoena their expert to be here, but this is another case that's been on my docket since 2021. So it's going to trial on that date. So anybody who wants their experts, you probably need to subpoena them. And Norma, we're recalling this for the 18th.
Yes, ma'am.
All right, that's when your jury trial is going to be. If you sign the reset form, you're excused. Dean Villarreal.
I'll just say.
All right, what is happening with Jonathan Boyd?
There wasn't the audience, but for a second,
Jason Goff,
Yes, Mr. Boyd, come forward. I see the file on Jonathan Boyd. All right. Mr. Boyd, we're coming back for jury trial on the 20th.
20th.
Yes, Wednesday.
Understood. I'm flying out to Philadelphia on Thursday. I'm the head coach of the mock trial team, St. Mary's. Our mock trial competition is in Philadelphia from Thursday through Sunday. And then I will also be out Monday and Tuesday. A friend of mine has been diagnosed with cancer. I'm taking him to the hospital in Houston on Monday and into Tuesday.
All right. All right. I'll see y'all back on September 20th. Norma, if you'll give them their reset form.
Understood.
All right. Thank you. And then, Mr. Goss, are you here for Stephen Ward as well?
Yes, sir.
All right. Could I see the file on Stephen Ward? And Stephen Ward, if you'll come forward.
Is ill as of this morning.
All right. And could I see your motion for continuance on that one?
Yes.
Sure. All right. And the court is calling 2021 CR 5164, State of Texas versus Jonathan Boyd. Could I have parties announce for the record for the state?
Brittany Mitchell for the state.
Defense?
Jay Norton and Nico Lewis, Mr. Boyd.
All right. Defense has filed a motion for continuance. The court will note that a previous motion for continuance was filed and granted on June 20th, 2023. The court will note that this case has been pending on the court's docket since August 5th, 2021. Motion for continuance is denied.
And Your Honor, I did just learn within the last hour that our child victim she woke up with, as a mom, I believe it's probably strep throat this morning. So we would just ask if, I know there's other cases, but if this does get pushed to possibly delay testimony for her to put on antibiotics.
All right, state you'll have to file your motion, but defense motion for continuance is denied. Thank you. Thank you.
Morning, Judge.
Good morning. Okay, I was telling everybody about our Scotland trip with Virginia, where we were in Scotland, and Hannah said, Stephanie, where the castle has been known to be haunted, and you're staying in the most haunted room. And so I was telling my story, people like, no, that's not true. I'm like, ask Hannah, it's true.
I would have moved. I don't do ghosts.
All right, so today is the plea deadline date.
So, Judge, the plea deadline was actually last week, and you had recalled it for today. There is a PF case that was filed while he was out on bond.
All right, everyone, please whisper.
Yes. It's an engaging or organized crime case. And so Melissa contacted Intake to try to get the file, because if we're going to work something out, we'd like to work him out on both cases. He's habitual. There's a sizable offer on the first case. What I'd ask the court to do is give us 30 days so we can try to get both cases worked out at the same time.
All right, Melissa. On this case, do y'all actually have the discovery on the engaging in organized crime?
I don't know how much is involved in that case. It's with our intake prosecutor. I emailed her the same day that we were set. I asked her to look into it. She's not gotten back to me. I know, just based on what Mr. Maurer and I have discussed as far as the facts of the case, the allegations, I imagine that it is quite voluminous. So I don't know how quickly she's going to be able to get it together. I can make him an offer on the case that we have indicted. If
you did, there's already one on the file.
But I don't know how much faster I can get her to get the ball rolling on.
And as far as the plea bargain, I mean, we're not in a position to reject it. I just would like to be able to resolve both cases at the same time, because I think the other case is going to be pretty significant based upon what at least I've read.
All right, so I'm going to recall it for November 6th. There will be no further extensions.
I'll send another email.
Right. Thank you, Judge.
All right, is there anything else?
No, that's it. Thank you.
All right, thank you for reporting, for dressing appropriately for court. Once you sign the reset form, you will be excused.
Judge, he's got a job right now, and we were trying to see if we can get him switched from, you on partial?
I'm on full house.
He's on full house arrest, to see if we can get him switched to.
You need to confer with the
Yeah,
state.
I'll talk to him. Good. Yeah, to see if I'll come talk to him.
So today is plea deadline date. Jury trial?
Well, Judge, I filed a motion to withdraw on all three of his cases. We have a
Could I see the
a
motion?
disagreement about representation.
All right, the court is calling 2025 CR 007775, 2025 PF 08119, 2025 PF 2025 PF 08120. Could I have parties announced?
Robert Maurer for defendant.
And are you Mr. Dollar?
Yes.
All right. So your defense attorney has filed a motion to withdraw in each of your cause numbers. So when will you be able to hire an attorney?
I'm gonna need appointed.
No, that's not how it works.
Represent myself then.
Okay.
I don't, how does it not work that way? I'm asking for a court-appointed attorney.
This is your court-appointed attorney.
He's withdrawn from my case.
Yeah, because I guess there's some sort of conflict. I don't respond to emails, and those emails don't come to me. Those emails come to the court coordinator, and then that email is sent to the defense attorney and to the state. I don't review emails.
Well, I've tried to contact Mr. Maher's office several times over the past 6 months with no response. I cannot get an answer.
Look, that is, I'd like to respond to that. Is complete nonsense. He has been in my office. He has met with me. He has reviewed the evidence. I've discussed the case. I've discussed the offers. He's not happy with the offer, and I told him then we try it.
Yeah.
But just to speak frankly, and he probably put this in the email, it got to the point where he offered me extra money, somehow thinking that was going to change how I represented people. And I said, I've acquitted people on murder charges on appointed cases. And I'm offended by his attitude and his actions, and I don't want to represent him.
No, actually, you said shut the F up and hung up.
I probably did, Judge.
Yes, you did.
Yeah,
All right,
I'm quite certain I did.
Mr. Maurer, state, do you have any objections? All right, Mr. Maurer, your motion to withdraw in all three cases will be granted. You'll need to retain counsel.
Thank you, Judge.
All right, Ms. Ferguson,
Yes, sir.
recall this in 30 days, and it's for the defendant to obtain an attorney.
Yes, Marie.
My bonds didn't have me parked up.
No, I didn't.
They told me, yeah, you did, and you called my pretrial officer and told them the same thing. Tried to get me locked up.